State versus Byron MacFarlane.
Good morning, Your Honor. Terrence McGinnis on behalf of Mr. MacFarlane. He is here at the trial table with me.
Your Honor, the agreement, this case is being called for the purposes of a plea. The agreement is the defendant's pleading guilty to the last citation, 21-282, driving under the influence of alcohol per se. The agreement is the state will limit its recommendation to 30 days executed incarceration to be served in the weekend or work program, and the state is going to agree that the defendant receives credit for time that he's already done in the right turn program.
Good morning, Your Honor. That's our understanding. Can you state your name, sir?
Byron MacFarlane.
Mr. MacFarlane, I'm going to show you the waiver of rights that we have reviewed and signed. You recognize this document?
Yes.
Did you review this with me?
Yes.
Do you have any questions regarding this?
No.
You understand these are the rights you're giving up by pleading guilty here today?
Yes.
So, may I pass it up to the court?
Yes.
Here you go. You got it, George? Here you go. Here you go.
Okay, you read and understand the waiver of rights,
Yes, sir.
and you freely and voluntarily signed it.
Yes.
Court finds that please freely and voluntarily given it. You'll get to the factual basis.
Your Honor, had this matter proceeded to trial, the state would have proven that on April 26, 2015, Montgomery County Police stopped the defendant after observing the defendant swerving, almost striking another car, and talking on a handheld phone. After stopping the vehicle, Montgomery County police officers observed the defendant with bloodshot, glassy eyes and the smell of alcohol coming from the car. The defendant stated that he had had a couple of drinks. Officers performed the standard field sobriety tests, which were not performed to their satisfaction, whereafter the defendant was placed under arrest. After arriving at the station, officers tested his blood alcohol, and it resulted in a .13, and all events occurred in Montgomery County, Maryland.
Any additions or corrections?
A minor one, Your Honor. It was the Maryland State Police that stopped him, and my client was not talking on the phone. He was using his GPS to find his location. Thank you, Your Honor.
The court finds evidence would be sufficient to find the defendant guilty. The court will find the defendant guilty. You wish to be heard, sir?
Yes, Your Honor. I would like to pass up my client's driving record, which shows currently no active points in this at this time. And Your Honor, I have several documents that I will pass up to the court. My client is 32 years old. He is a graduate of University of Maryland and of the University of Baltimore School of Law. And he is currently employed in Howard County in the courthouse system. As a result, soon after this matter, Your Honor, my client went to Columbia Addictions for an evaluation, and I have a copy which I would like to pass up to the court. May I approach you?
Yes.
And their recommendation is for a series of programs that my client is now he's involved in, continues to go to that. Further, as a result of this, my client attended the Right Turn program, if the court is familiar with that. That's a residential program. He went for 2 separate weekends and has been there and has successfully completed both of those. And I would pass those completions. I've already given them to the station. He has completed both of those weekends. He continues with Columbia Addictions. If the court would want, I have a follow-up, just a confirmation letter. And he attends the meetings on a regular basis. I have confirmation, which I will pass up to the court on that. Let me defer to the corporate paperwork. My client has been working hard at his sobriety. Honor, two other things. My client has enrolled in the Interlock program, and he has that on his vehicle at this time. That was not a provision of the NBA administrative hearing. He did that voluntarily. And if I may, give a little background on my client, Your Honor.
Pardon?
If I may speak a little on the background of my client.
Yes,
As I
please.
indicated, he's 29. He graduated from law school and is currently 32. I keep saying 29. He's 32 years. I make him younger than he is. And he, as I say, he's currently employed at Howard County Circuit Court. He has been active in the community. He served on the Central Committee of one of the political parties for 4 years. He teaches at Howard University, teaches States and Trust course down at Howard University. He's a member of the Howard County Bar, the State Bar, and is active in all of those. I'm sure everyone comes in front of Your Honor on a DUI and says they're taking it seriously. But as you can see from the paperwork I have provided, the steps that my client has taken, he has been forthright in this, that he understands that this is not a casual occurrence. This is a problem, and he's dealt with it. He's doing it in a straightforward fashion. I have, from one of his acquaintances, I will pass up a letter of character reference that they are called on. Attesting to his sobriety, to his background, and to the steps he's taking at this point in time to deal with this matter. And I have heard the state's attorney indicate that the recommendation is 30 days to serve on weekends. We would ask the court, and I'll have my client speak in a moment, to consider the steps that he's taken, the 2 weekends that he has done as the sufficient for the purposes here today. Now, if I may, Mr. MacFarlane, you have the chance here to speak to the judge. Anything that I didn't say or anything you want to say to the judge directly. This is your opportunity. Something you wish to say?
Yes, please. Good morning, Your Honor. First, let me just say I take full responsibility for my actions, and I am prepared for the consequences that please the court. Second, I'd like to say that I deeply regret that my actions endangered the safety of others, including the officer who arrested me. I especially regret that I have embarrassed and burdened my family and friends, especially my mother, who's here with me today and shouldn't have to be here. And I also regret that I've burdened the court and the state that I love and has been my home my entire life. Your Honor, over the last couple of months, I've been able to come to a conclusion, and I'm relieved to be able to say today, which is that I'm a recovering alcoholic. And I've started a journey that I know is going to last the rest of my life. And day by day, I'm learning more about how my own shortcomings, making amends to people who I have hurt over the years, being of service to others, and continuing on a course of treatment that will prevent something like this from ever happening again, and ensuring that I am the best person I can be to my friends, my family, my community. And thank you for your time.
He has one prior.
That's correct. That was 2007.
Does the state have anything it wishes to add?
I do, Your Honor. Thank you. Given that it was I think there are 2 aggravating factors in this case Your Honor should consider. The first being that this is the second offense. The first was back in 2007. And here, the facts of this case, he's swerving. He almost causes a collision. He almost strikes a car. And he's driving on a cell phone, in addition to being intoxicated. When I first looked at this case, I thought this was a case where he needs to spend some time in the Montgomery County Correctional Facility, MCCF. However, given I have taken this in this recommendation, only the weekend of work program, and that's for 30 days, I think that takes into consideration that he has taken it seriously. I've heard what he's had to say, and I've heard counsel called me several weeks ago to try to convince me not to ask for jail, and I agree with him since he is taking this so seriously. He has done a lot of treatment. He did the right term program, which I'm glad he's done. I don't think that's enough. I think he needs to be punished further, but I think the weekend of work program is a good compromise between actual time in jail and no jail. So I'm going to ask for 1 year, suspend all the 30 days to be served in the weekend of work program. I'm trying to give him credit for the 4 days he spent at the right turn. I'm also going to ask for 2 years of supervised probation. I want to ask, as a condition of that probation, the defendant be ordered to have an interlock device installed on his vehicle for any car that he owns, that he operates, or has permission to operate, and that he also attend a MAD victim impact panel.
How many days credit did you say?
Was it 2 weekends?
It was 2 weekends, but
4 days.
4 days.
If I may, Your Honor.
Yes.
It is true that my client was using the handheld device for GPS. He was not talking on the cell phone. It's a distinction. I think it needed to be noted. We would ask the court, if the court is so inclined to provide for additional incarceration or something of that magnitude, that my client attend another right turn weekend. What he has indicated to you, that this program and the follow-up care that he is doing, the meetings that he attends, the Columbia addictions, the right turn have all been helpful to him. And I know that the state is looking for punishment, in this case, the rehabilitation for a young man working his way through this problem. I think that is a better course at this point in time. We would ask the court to consider a right turn program as opposed to incarceration. And I did have the opportunity to speak to the trooper who was here today. My client was quite prompt. He was polite and cooperative at the scene. There was nothing unusual about the stop and no problem at that time. So we would ask the court's consideration on that. And being mindful that he already has the interlock on his vehicle.
The court will sentence the defendant to pay a fine of $325 plus costs and CICF fee. Sentence the defendant to 90 days. Suspend the 90 days. Place the defendant on 3 years supervised probation with the DWI monitor. The defendant is to complete the program at Columbia Addiction Center to do 2 more weekends at right turn, and the interlock is to be installed for the period of the probation.
Your Honor, may I make 2 specific requests regarding that? As I indicated, my client is teaching at Howard University, which is in Washington, D.C. The normal condition of probation is that he not leave the state without permission. We would ask the court to allow him to leave the state without permission of the supervising probation officer.
No objection.
And you're okay.
Court will note defendant allowed to leave Maryland. You have 30 days within which to appeal my decision, 10 days to ask for a new trial, 90 days to ask for reconsideration of sentence. The remaining counts.
You can place him on a step docket for 90 days, unless he wants to waive his right to appeal.
There are remaining charges other than the one that you pled guilty to, and the state is saying if you waive your right to appeal, they'll dismiss them now, otherwise they'll put them on the inactive docket for 90 days. Do you wish to waive your right to appeal?
I believe the defendant indicated he wishes to waive his right to appeal. Pursuant to the waiver, now proceed to the remaining counts.
Defendant, having waived his right to appeal at the request of the state, the remaining counts will be entered nolle prosequi.
Thank you, Your Honor.
Here are your documents back, sir.